Broadcasting worldwide from beautiful Santa Monica, California. It's time to get real. What makes someone rich and successful while others stay stuck in the grind? How can you maximize your potential, live your dreams, and build your wealth? Taking an honest look at our world and the markets that move it. Let's talk to successful people and take a look inside their heads. Let's simplify success and spread the wealth. Let's prove the American dream is still alive. This is Real Business Talk.
Welcome to Real Business Talk. My name's Robert Crawford. Today's episode will be about asset protection, how to protect your assets through trust and living wills, really to make sure that everything that you've accumulated over your life is not only protected from lawsuits, but also protected for your future generations and your family. Our host today, our guest, will be Jeffrey Condon, who is an author. Let me just read a little bit about Jeff before we bring him on. Jeff is an attorney who's been practicing in the field of trust and estates since 1987. Pretty much my entire life he has been doing this work. He's received a bachelor's from UCLA, and then he got his law degree from Whittier College School of Law in 1987. He's currently based out of Santa Monica, California, just on Ocean Park, I believe, so not far from our offices. In 2008, he authored and published The Living Trust Advisor, Everything You Need to Know About Your Living Trust, and has published a few books since there, and I think he has one coming out this week as well. Jeffrey has been cited on over 100 newspapers and magazine articles discussing inheritance planning, including the New York Times, Los Angeles Times, Washington Post, Wall Street Journal, Time Magazine, and Business Week. Jeffrey has discussed various inheritance planning issues on over 70 radio channels as well, including The Money Club on CNBC, Primetime News on CNN, and One-on-One with John McLaughlin on NBC. It's a really interesting topic, and we'll bring Jeff on now to kind of introduce himself as well, but I think it's something that's not the most exciting topic in the world, but something everyone should be familiar with. So Jeff, I'll lead it off to you, and you can kind of bring us into this whole asset protection world.
Sure, Robert. Thanks very much for this opportunity, and you sure know how to make a guy feel old. That I've been practicing for 30 years, which is essentially how old you are. So yes, thank you so much. so much for humor and trying to. But you're right. This is the topic of. The topic of inheritance planning, living trusts, estate planning. I think the normal person hears the lay person hears that and immediately it sounds like a sleep-inducing topic. The trick is to try to keep this topic interesting and accessible, and that's what I have spent my entire career attempting to do, and I believe I have done that with. The books that I have written, one of them which you mentioned is The Living Trust Advisor, that came out in 2008, and the revised edition of that book is being released in a few days. It's very exciting because it's a hardcover. Every book I've had before has been in paperback. This is a hardcover. It's kind of at least when I'm sitting around with my friends and talking with them and saying, "Hey, check out this book with my name on it." It's kind of impressive. But anyway, the topic of inheritance is something that I have been dealing with for my entire estate planning career, for my entire career as an attorney. So when you talk about asset protection in the estate. In the inheritance context, this is what we're talking about. Robert, if you are like most of my clients, or the people out there are like most of my clients, you're going to take steps to protect your assets during your life from risks of loss. If you feel that something is coming along in your life, like a bankruptcy, or a lawsuit, or a judgment, or any kind of risk of loss that your money and property can be subject to, you're going to take steps during your lifetime to ensure the preservation of your property, to make it immune from those risks. Because you've worked your whole life to accumulate your assets, the last thing you want to do is to lose them to creditors. Well, that's during your life. Now, that's not the kind of business that I'm in as far as asset protection during your lifetime. But what I do is asset protection after your death. And I know that sometimes people get a little weirded out, so to speak, using the term death and dying so casually. But it's hard to talk about these concepts while tap dancing around death terminology. So after you die, because that's what we're talking about, you want to ensure that the assets that you have accumulated all your life will go to your children and go to your grandchildren in such a way that they are protected from their risks of loss. In other words, what good is it if I've done a plan where I've saved you hundreds of thousands of dollars in estate taxes, and it's a plan that has kept and maintained family harmony with your family as they enter into the inheritance arena? But what good is it if they're in a position to lose it to who? Well, they could lose the assets that they've inherited to their wives and to their husbands in a divorce, or they could lose it if they've gotten into an accident and have insufficient insurance, or they could lose it to the IRS if they have any income tax problems, or they could lose it if they belong to some crazy cult and they give it away all with respect to some kind of tithing requirement required by that crazy cult. Or they could just lose it to their own financial immaturity. You may have great kids, and they may be on the right track to financial immaturity, but at the time of your death, they may be at the wrong station. So there is just a host of problems and risks that exist in your children's lives and your grandchildren's lives that could subject their inheritance to loss, to attack, to diminishment. And my job is to recognize that problem and to come up with a plan in your living trust or other inheritance plan so that the assets that you leave to your children and grandchildren are protected from those types of problems. So when we talk about asset protection in the inheritance arena, that's what I do. I recognize the problem and I come up with a solution to resolve that problem.
Great. I mean, I think the first thing is I think people don't have an understanding of what a real asset is. I think obviously people assume real estate. That's a pretty no-brainer one. If you own property, there's a lot of protection you need from the lawsuits that could come against that property, from the inheritance. Now, what if someone were to own property and they didn't properly set up a living trust or any type of protection during their lifetime, and God forbid something happened to them? What would happen at that point?
Well, if you have a judgment against you, say somebody sued you and they got a judgment, and then they reduce that judgment to an order. That order is recorded with the county recorder of whichever county you happen to be in, and that judgment will exist against you for the rest of your life or until that judgment is paid. And that judgment against your name can have a significant and devastating impact. You won't be able to get a loan. You won't be able to sell your assets without having those assets then be used to satisfy the judgment. There is just a whole host of problems that come along with getting with that type of situation. It's not a good situation to be in, obviously. So, and essentially, when we're talking about asset protection, that's what we're talking about. it's about judgment creditors. If you get into a lawsuit and you don't have sufficient funds to pay that lawsuit, then your assets will be used to pay that off. And the assets include anything. It could be your house, apartment building, bank account, brokerage account, whatever. If that judgment creditor obtains a recorded judgment against you, then your money and property and your assets will be subject to diminishment or complete garnishment as a result of that. So a lot of people say, well, then, gee, I just got sued. I need to move over my assets to somebody else, or to the Cook Islands, or to some third party, so that I don't own those assets, and so that those assets won't be subject to a judgment creditor. Can I do that? And the answer is no. Certainly, I guess you can do anything, but the law looks heavily on those who attempt to do asset protection after the matter that has arisen to diminish your assets has arisen. There's laws against laws, criminal, in the criminal and the civil worlds, that will hold somebody criminally liable and civilly liable if they attempt to move assets just to avoid judgment creditor. So the trick is to anticipate whether or not you're going to be the subject of an action, and then move your assets prior to that action being filed. Not a lot of people have that sort of foreshadowing.
Yeah, the foresight to do it. I think that's a big point, because I think a lot of people don't think about a lot of this until something bad has already happened.
Right. And so a lot of people say, Jeff, I want to move my assets. Let's say that a lot of times this comes up when I have apartment property owners, and they say, hey, Jeff, I don't have any lawsuits against me at this time, so everything's great. But I am so concerned about a tenant suing me for just the most ridiculous thing. And if some crazy judge or some crazy jury finds in favor of that tenant, then there goes the apartment building. So I want to establish an irrevocable trust. I want to put my apartment building, I want to put it into an irrevocable trust where I still get the income, but I don't own it. Or I want to establish some type of LLC, limited liability corporation, so I can put the property in there, so that if I get sued, the LLC, acts as sort of a protective shell. Or I want to establish a C corp or an S corp or some kind of entity that divests that apartment owner from that property. And I'm not one to shy away from work or to charge fees for that work. I'm happy to do that, but I have a philosophy, and that is I don't want to sell somebody something that they don't need. And a lot of the times these asset protection devices for these apartment property owners are overkill. Sometimes the cure is worse than the disease. And the disease in this case is not owning their property anymore, or adding extra layers of complexity to the property ownership that they maintain. I typically maintain in that situation, or I advise and say, look, just, forget all of that. Just make sure you have a lot of insurance and you're fine. And typically, I would say, 9 times out of 10, that resolves the problem. So, in a lot of situations, asset protection before the specter of litigation from any person is unnecessary. But that doesn't mean that people don't do it. People do LLCs all the time, and I think is probably the main asset protection device that we have in the United States. That's fine. Maybe around $5,000 or so to set up, and there are requirements that must be maintained and undertaken each year fees that have to be paid each year to the Secretary of State of the state that you're in to maintain the LLC. A lot of times these LLCs, or excuse me, in a lot of states, they're being somewhat undermined by state legislatures that say that single person LLCs are no longer valid, which is the majority of the LLCs that take place or that exist. So the LLCs are still out there. Domestic asset protection trusts are still out there. But a lot of times, like I said, they're overkill, and they may be undermined by whatever state's laws that are existing in the law in the state that you happen to be. So that's with respect to during your, to what takes place for asset protection concepts anyway during your lifetime.
So it seems like having a good insurance plan is kind of step one on anything, and then having extra protection as far as setting up an LLC or a trust is kind of extra protection on top of that. And it seems like the big deterrent to maybe not want to go into setting up an LLC or a trust is really the cost. It seems like it really cuts into your profits if you're paying fees every single year to keep that entity active.
Yeah, well, that's essentially it. Insurance number one. As my dad used to say, my dad taught me this business. He was in the business for 50 years. He said, Jeff, clients don't do what they don't understand. And a lot of times these asset protection plans and these LLCs can become complex to the extent that people don't understand it. People don't do what they don't understand. So keep it simple for people. And the simplest thing is insurance. And sure, LLCs, it's a very popular method to create a protective shell over the assets that you own. The fees are maybe somewhat negligible. I didn't mean to give the impression that they were something that to be avoided, or that it was necessary to avoid them. But I think in California, it's $800 per year to maintain the LLC. But the main drawback of any protective plan that exists while you're alive is the management structure. If you have an LLC, if your property is in an LLC, you can't just do anything with it. Now you have to have shareholder. If there are other members of the LLC, you have to clear everything with them via membership meetings. You have to adhere to the numerous requirements. No matter what you do, it seems that there's a requirement in the operating agreement that speaks to it. So, but this is what people do. They have LLCs, and that's fine. And everything that I've read regarding the LLC versus the S corp and the LLC versus the C corp, it seems that the LLC is the predominant and the most effective measure of maintaining asset protection during your lifetime. I know that if you're going to pick a C corp or an S corp, I believe that decision as to which one you're going to use is more of an income tax driven decision rather than a estate planning decision, which is why I leave that decision to the income tax people. I don't get into anything that is beyond my bailiwick. But everything I've read seems to me that the LLC is the predominant measure of asset protection. But again, I would say use that for second place. First place is just make sure you maintain a lot of insurance at a comfortable level.
Yeah, especially in the real estate world, I think LLCs are generally recommended. Do you see any difference between someone that maybe has, a small amount of assets, maybe their own personal home and possibly an investment property, compared to someone that has multiple assets? Maybe they own a dozen investment properties. Is there a different structure between the two that you would recommend?
My recommendation is if you're going to engage in the LLC process, then it should be a different LLC for each separate property. Because if you have one big LLC and you shove all of your properties into that one LLC, then then one problem that you have with one property or one tenant in one property could adversely affect and bleed over into all the other properties. So so that's the general rule. One LLC per property. So if it's just one person with one apartment building, one person with one apartment property, then it's just that's easy. But yes, if you have 12 different properties, then you're going to make some lawyer really happy because now you got to do 12 separate LLCs. That's just the way it is. That's just the way it should be.
Interesting. So we've spoken a lot about protecting your assets from really aspects on the legal front if you get sued while you're living. Let's talk a little bit about the probate and trust and the will aspect to protect your assets after death, to make sure that they easily pass on to who you want them to pass on to. There's a lot of people that believe that they own a house, they don't need any protection, and once they pass away, they don't realize that not necessarily is it going to go to the family member or friend, if you don't have family members, that you want that property to go to. Sometimes it actually gets caught up in the court system. Do you want to touch on that a little bit?
Yeah, sure. Well, essentially, the main vehicle in America by which we leave inheritances to our children and grandchildren is the living trust. Wills are kind of passé. My general rule of thumb is that if you have real estate, you should have a living trust, because the living trust will take that real estate and transfer it to your children or grandchildren after your death without a probate process. Imagine that I've been to a lot of my competitor seminars, and I've heard the living trust described in very complex terms, and a lot of people shy away from it because they don't understand what it is. Essentially, the living trust is a bucket. It's a bucket that you put your assets into during your lifetime. That's all it is. You put title to your house, title to your cars, title to your apartment properties, title to your fancy dogs and cats, whatever it is that you own, title to your brokerage assets, bank assets, and you put them into this bucket. And during your lifetime, you own the assets in this bucket. You own them. And during your lifetime, you are the manager of the assets in this bucket, which means you can wheel and deal. You can sell and you can buy and you can exchange and whatever you want to do. And during your lifetime, you are the beneficiary of the income and the principal of the assets in this bucket. And this bucket comes along with a set of instructions. And those instructions say exactly what I just said. You, the one who set up this bucket, are the owner and the manager and the beneficiary. And it says what you can do with these assets in the bucket during your lifetime. And the instructions say, do whatever you want. Sell them, burn them, give them to some guy walking down the street. Whatever you want to do, they're yours. Wheel and deal all day long. Buy and sell. But these instructions also say what happens with these assets in the bucket after you die. And it says who's in charge of transferring the assets to the beneficiaries, and it says who your beneficiaries are. And these instructions say that your after-death agent, the person you've named in those instructions to carry out those instructions, will transfer the assets to those beneficiaries. And that's what the living trust is. It's simply a bucket of your assets that comes with a set of instructions to describe who gets them after you die, and appoints your after-death agent to carry out those instructions. It's very simple. But now the question is, what are those instructions? My job in the subject and the main subject of the books that I've written is to ensure that those instructions are right and appropriate. And in my world, right and appropriate means that it goes to the people that you want them to go to, and that the people who get them do not fight and have conflict over the inheritance and the inheritance division, and that they go to them in a way that minimizes the IRS involvement. In other words, leaving more to your children and grandchildren and less to the IRS. And so when you have these instructions that say who gets what when you die, and let's say those instructions say that goes to your kids, well, you do not want to leave those assets to your children outright, which means just giving it to them, leaving it to them, and saying, here you go, enjoy. Because what happens is now they are the owners of their inheritance. They own it, and now they can do whatever they want with it, and they can also lose it to their creditors, lose it to their ex-spouses, lose it to the IRS, lose it to anybody they want to give it to. That's not what you had in mind. What you want is, what you have in mind is that you want your assets to go to your children, to be used for them, and then on their death to go to your grandchildren, your children's children. And if they don't have any children, then to your other kids. That's what you want. And so you don't want to see it diverted from all of these risks of loss in their lives. So you do not leave, this is asset protection after you die. You do not leave your children an outright inheritance. That's passé. You want to leave it to your children in something that we call a protection trust. The protection trust is a term that my dad and I coined in our books, and we're somewhat associated with that term. And the protection trust, imagine that you're building a castle wall around the inheritance. And this castle wall is going to protect the inheritance from these risks of life, risk of loss in your children's lives. And so your children will not receive the property, the money and property, the assets, whatever it is, outright. They'll receive it as trustee of their protection trust, which means that they're still in charge. They're still in charge of their money and property, their inheritance. They still can, and so they're the trustees, they're the managers. And your children will be the beneficiaries of the income and principal of the assets in that protection trust. But this protection trust says what the kids can do with it and what they can't do with it. It says they can use it for their health, they can use it for their support, for their education, for their children's education. They can use it to buy or refurbish a residence. They can use it to establish a business. They can use it to establish an investment program. But it doesn't say they can give it away. And it doesn't say they can lose it to their creditors. And it doesn't say they can put their spouse's joint names on it. In other words, it says what it says, and it doesn't say what it doesn't say. So the effect of that is that while they're in charge of it, they still must use it for the purposes, they can only use it for the purposes set forth in that protection trust. And then it says that when the child dies, that the assets will not go to that child's spouse. It won't go to some boyfriend or girlfriend of your child. It will go to their children, your grandchildren. And if, like I said before, if you don't have, if that child doesn't have any children, then it will go to your other children. And if those other children aren't alive, then it will go to your other children's children. This way, we keep the money and property in the family bloodline without risk of diversion. Because my dad used to say, "Hey, listen, I like my kids, but I love Jeff's kids. I like my kid, I like my children, but I love my grandchildren. And the grandchildren are the ultimate dividends in a lot of people's lives. So they want to ensure that the money and property, while it can be used by their kids, will go to the next generation after that, to their grandchildren. So that's how we use the inheritance plan, the living trust, to provide asset protection for the children of the person setting up the living trust.
Interesting. So circling back around, for example, if you were to, while you are alive, set up multiple LLCs because you have multiple investments, and then you put all those LLCs under the living trust, is really what you're recommending as probably the easiest and best way to protect it for your future generations.
Well, that's correct. And I mean, I suppose that the technical way that this would be handled, I mean, if you would be that you establish an LLC and you transfer your real estate into the LLC. So record title of the property says the Jeff Condon LLC, whatever it is, and then the LLC, then you also then establish your living trust. So now, living trust, like I said, is a bucket, and you want to transfer your assets into the bucket. So what does this mean? It means that now the LLC transfers it's all of its membership interests to the trust. So the property is owned by the LLC, and all the membership interests in the LLC are in the living trust bucket, and therefore subject to the instructions of the living trust that have been set up. So and so there is that, I suppose, double layer of protection that you just mentioned.
Interesting. So with the living trust, does that also protect you? You mentioned the IRS. Would that prevent something like the estate tax? Or would it just limit that and maybe a little less than it would be without it?
Well, that's interesting. There's two facets of inheritance planning. One is the family side, which is making sure that the money and property that you leave to your kids doesn't create inheritance conflicts between them, and that doesn't create a situation where they can blow the dough. And then there's the money side, which is all about estate tax. Some people call it the death tax. That's kind of a misnomer. There is no tax on death. People die all the time, and there's no tax on that event. But there is a tax on the transfer of wealth after death. So the death tax, the estate tax, is essentially a wealth transfer tax. It's a tax on the transfer of wealth after death. Right now, as we sit here, the IRS has said that you can transfer up to, well, let me put it this way, you can own $5.5 million of assets at the time of your death without there being a wealth transfer tax or an estate tax. I would say that 95% of the people in America don't have $5.5 million of wealth. So there really is nothing beyond the living trust that needs to be done to do this estate tax planning, because the simplest estate tax planning is simply just to own less than that 5.5 million exemption amount. Okay, well, let's say that people listening to this have more than 5.5 million. If you're a single person, the living trust does not do anything to reduce the estate tax, because that person, with or without the living trust, has that $5.5 million exemption. The living trust gives you nothing additional to fight the estate tax. You already have that because you have a 5.5 million exemption.
Mm-hmm.
But if you're a married couple, and you have a community property trust or some type of joint trust, then yes, the living trust does help reduce estate taxes by combining both spouses' exemption amounts. So now, instead of just one person having a 5.5 million exemption, we have two people with a combined 11 million exemption. So let's say they have dad and mom. Dad and mom have let's call it $11 million of real estate assets. Okay, dad dies first, and everything goes to mom. And the mom is the sole survivor and the sole owner of the living trust assets. So when mom dies, mom can combine her exemption amount of 5.5 and her deceased husband's exemption of 5.5, which means that the entire 11 million will go to the children and grandchildren free of tax. Now, having said that, I just want to say that we live now in a world of estate tax portability, which means that even without the living trust, in this example, the surviving mom has the ability to say to the IRS, I want to use my deceased spouse's exemption amount. So even without the living trust, the surviving spouse is allowed to use her deceased husband's exemption amount for yet a combination of $11 million exemption amount. So sometimes people say, oh, you need a living trust in order to reduce estate taxes. Yeah, that's true, you do, but you also get that without the living trust as well. So I wanted to put that out there in case people are being badgered by these living trust firms that say you must have a living trust to reduce estate taxes. That's not entirely true.
Yeah, very interesting. I didn't even know about the $5.5 million exemption. So it really doesn't even become an issue unless you have probably tens of millions of dollars worth of assets.
That's correct, Robert. Really, the main purpose of the living trust is to avoid the probate process after death. I mean, at least these days. I mean, you never know. We could get somebody new in office, and there's this harmony between the executive and the legislative branches, and they decide to reduce the exemption amount from 5.5 million back down to 1 million, which is where it was a few years ago. So that could certainly happen, and therefore the living trust becomes extremely relevant with respect to preserving the exemption amount of the first spouse to die. And maybe or maybe there'll be a new law that says no longer do we have the portability of the deceased spouse's exemption amount over to the surviving spouse. So you never know what we have, and so the living trust could become relevant again someday in that regard. But right now, as we sit here, the living trust is not truly needed for estate tax planning, but it is needed for inheritance planning, which again is to avoid the probate process, to avoid conservatorships, and to leave money and property to your children and grandchildren in such a way where it avoids family conflict and where it avoids the inheritance being subject to the risks of loss in the lives of the persons inheriting.
I think you've mentioned a lot of really good points on the value of asset protection, but you've also mentioned a few times why you want to avoid the probate process. Maybe you want to touch real quickly on what the probate process is and why you want to take these actions to really try to avoid it.
My dad used to say probate's not the end of the world. If your money and property have to go through probate to get to the next generation, well, oh well. But having said that, when I pose to clients, when I say to them, the living trust will avoid the probate process after you're gone, and therefore, and since probate involves time and money, probate is the court-supervised process of transferring assets from the deceased to the living, and like any court-supervised process, it involves courts, and it involves time, and it involves lawyers, and it involves attorney's fees. I would say that the probate fees are about 6% of what the assets of the assets going through probate, and it would take about a year if there are no problems. So and then I say that the living trust is designed to avoid that. Is designed to avoid that by simply appointing someone else, like a private party, like that after death agent, to do what the probate court does, which is to transfer the assets from the dead to the living. So if you use a will. You use a will to go through to transfer your assets. It takes the probate judge to transfer those assets, and that's the court process. If you use a living trust to transfer your assets after death, then it's the persons that you appoint to carry out those terms. Typically, that's going to be your kids, and that will avoid the probate process. That avoids the lawyers. That avoids the courts and all that stuff. But then I would pose, how important is that to you? I'm sure you're going to make some lawyer happy about the probate fees. I mean, that's all great. But, how much do you care about saving money and saving money for your kids after your death? How much do you care? And a lot of people say, well, after my death, who does care? It doesn't really matter. So they say, then just sell me a simple will, Condon. That's all I need to do. And that's fine. Like I said at the beginning of this, I'm not going to sell something to somebody that they don't need. But most of the time, the response is, I do care. I don't want my kids to have to go through that, go through that probate process. And sure, sign me up for a living trust. And so that's the difference. That's the difference. And if you've heard the old adage, if you use a gun, go to jail. Well, use a will, go through probate. But if you use a living trust, you don't go through probate. You spare your family that process. It's certainly a goal to be lauded. It's certainly a valid goal. But I don't want to be one of these lawyers that has people go into hysterics that say, "Oh, you must avoid probate. You must avoid probate." I'm somewhat of a realist because I know that a lot of folks don't have the attitude about probate avoidance. Just to in other words, if a lot of folks will say, "Gee, well, if the living trust is more expensive than a will, then why don't I just do the will and let my kids have to go through that?" Or what I find more is that if clients who don't have kids, they do wills most of the time because they're saying, "Hey, who am I saving the money and property for to do a living trust? Just let them go through it." So hopefully, in that little diatribe, I've explained the difference between, I've explained the concept of probate and how probate can be avoided with the living trust. But like I said, it's not for everybody.
Yeah, no, I think you've definitely clarified that a lot for people because I think when people somehow, maybe it's the media driven or whatever it is, they think wills are the way to go to protect their assets. And they don't realize that while a will can protect it, you do have to go through the court system, while a living trust can avoid that. So now let's say someone realizes that there is value in setting up asset protection. How would someone pick out a great attorney to help them? And what do you think the average fees for something like this would be? If someone's looking to set up a living trust for their assets.
Well, I've seen some Los Angeles Times ads in which these firms that do a volume business of trusts and estate planning setups. I've seen them advertised for $595. But you get what you pay for. And when these trusts, in the old days we called them trust mills, and they just do volume business, and the people who are preparing the trusts are not attorneys. They do have an attorney at the head of the firm, but a lot of people who I've talked with after they've come from these meetings with these trust mills, they say they never even met the lawyer that has prepared their documents. I think we've all lived long enough to know you get what you pay for. And when you get these big firms that that just try a one-size-fits-all trust, you're not really getting tailored and individual treatment. But so I think that most people would benefit by at least talking with an attorney about what their estate plan would consist of. And in my opinion, that first meeting should be free. It should be free because a lot of times people don't want to see lawyers. They've never had to see a lawyer in their life. They've never been sued. They've never been divorced. They've never set up a corporation. A lot of times, the first time people ever see a lawyer is when they come and see someone like me, when they're setting up their inheritance plan. So I want to make that as least daunting as possible. So in order to do that, I don't charge a fee for that first consultation. And besides, it's only at that first consultation that the lawyer can glean from the potential client what that client's needs are and what those client's needs are not. A lot of times I've said, you don't need a living trust, you don't even need a will, goodbye. Thanks for coming. And that's fine. But if someone does need a living trust, if someone does need some sort of estate plan, I have a sort of a canned response as to what the fees would be, at least in my office. And that response is, it's usually somewhere between $2,000 and $5,000. And where you fall in on that scale depends upon what bells and whistles we're throwing on and what bells and whistles are not. It's like buying a car. The more complexities, the more things you throw in there, the more expensive it becomes. And so it only makes sense. I can't charge a fee to tell people what the fee is going to be. But I will have people say, well, Mr. Condon, that's a lot. You know, I can't, you know, that they've seen other people who charge maybe less. And I say, that's fine. You know, go ahead and, you know, it's your prerogative. Go ahead and do business wherever you want. But, you know, what I do is I don't do trust on a volume basis. I've been doing this for 30 years. I know what I'm doing. I like to think that I offer the Cadillac level of estate planning. And it's a very personalized treatment. But without regards to me, I think that anything that anybody's looking for in a lawyer should be that the price should be competitive, and the services should be one-on-one and personable. And also the fees should be a flat fee, which means whatever the charge is, it's one charge and that's it. For no matter how many times the client comes and visits the attorney, no matter how many times that the client comes and talks with the attorney or speaks with the attorney on the phone, the client should not have to look at his watch just to see how much time he spent, you know, out of fear of being billed. A flat fee makes it a lot easier for everybody involved, and a client should have a comfort level in talking with the attorney and not have to, you know, by not having to calculate how much time is this phone call costing and how much time is this meeting costing. It should be a flat fee for all services.
Great. You know, I really appreciate your help. I think you've clarified a lot of things for people watching this today, especially with the idea that you should set a flat fee instead of getting billed for every email that the lawyer sends to you. I think that's a really good point that people usually don't realize, and just being able to even ask that question when you're talking to an attorney could save you plenty of headache and cost. So Jeff, you know, obviously if someone wants to learn more, they can read your books. They can go on Amazon and search Jeffrey Condon, and your 4 books will pull up. I know you have a new one coming out soon. Do you want to talk about that for a second?
Oh, sure. When you go onto the Amazon site, it's on the one on the right. It's the orangey cover. It's the revised edition of the book that I first published. That was first published in 2008. It still constitutes a new book, according to the publisher. This is called The Living Trust Advisor: Everything You and Your Financial Planner Need to Know About Your Living Trust. And this book operates on 2 levels. One is on the layperson level, explaining everything about a living trust and how the living trust functions while you're alive, after the death of the first spouse, and then after the death of the last spouse. And it comes with all kinds of admonitions about what to do and what not to do. And it also works on the level of the more sophisticated financial person, the financial planner, the financial advisor, the insurance broker, the real estate broker. It gives instructions on how to for the more, you know, I'm going to do quotes here, quote unquote, the more sophisticated business person on what to look for in their client's living trust. Not asking them to practice law. I'm asking them to help recognize issues so they can ask their clients the right questions. Because it's the financial planner, it's the business advisor that's meeting more with the client than the attorney is. So the financial planner is on the front lines of their clients' lives, and they are in a better position to be able to recognize issues. So this book helps the financial planner, the business advisor, the financial sophisticate, the one who has clients, who has living trust, to help that client recognize the issues that come up in estate planning and inheritance planning, and then motivate that client to see an attorney with regards to amending that living trust to address that particular issue. And there's never been anything like this done before in publishing history, so I'm really excited, and it's going to be very different. I'm looking forward to seeing what happens. So that's coming out, and that's very exciting. If people want to talk to me, there's no charge to talk to me on the phone. If people want to visit my website, my tech guy did a great job on my website. At least that's what I'm hearing from people who visit it. It's Condon and Condon.net. That's CONDONAND.net. It's my name twice with the word "and" in the middle. There's videos on there. There's links to the book. I think there's even a passcode that people can look to get a 30% discount on the pre-launch of the book. I believe that may be offered through the publisher, which is Wiley.com. So if you don't see it on my site, please go to Wiley.com if you're interested in getting a discounted book. Robert, I appreciate this opportunity to hear myself talk, to hear the sound of my own voice. I hope that the people who have viewed this got some meaning out of it. The last thing I want to do is be bored and be boring. So I hope that the people who were watching and listening were not bored, because I pride myself on making this subject, which can be a real slogfest, be accessible and understandable, and maybe even entertaining if I've done my job right.
Yeah, I think you've taken a complex topic and really simplified it for everyone today to give them a clear idea of what they need and what they don't. And people that do have assets that they need to protect, you've given them some recommendations, and I highly recommend they give you a call if they're in the California area. Can you take on clients outside of Los Angeles or California, or is that something that's not within your scope?
No. I've done living trust for people in many states. My books have given me a renown beyond my Santa Monica, California office. So all I have to do is just do a little bit of research on the trust laws of that client's state that's other than California, and pretty much trust law in one state is the same in other states, except for Louisiana. Louisiana bases itself in the old French law, and that's a little different. I won't take any business from anybody in Louisiana, but I've done trust for folks in many other states, and I'm happy to accommodate in that regard if someone calls upon me.
Sounds great. Well, Jeff, I really appreciate your time. Again, you can reach him at his website, which is Condon and Condon.net. You could just Google Jeffrey Condon, and I'm sure all your books and your website will pop up. And he's very accessible. You can reach him through email or through the phone and get all your questions answered. You can watch this video at realbusinesstalk.com. We'll also post it on We Are Realty. And if you have any other questions, feel free to comment on the video below and subscribe for more videos like this. Thanks, and have a great day.
You too, Robert. Take care.
Broadcasting worldwide from beautiful Santa Monica, California. It's time to get real. What makes someone rich and successful while others stay stuck in the grind? How can you maximize your potential, live your dreams, and build your wealth? Taking an honest look at our world and the markets that move it. Let's talk to successful people and take a look inside their heads. Let's simplify success and spread the wealth. Let's prove the American dream is still alive. This is Real Business Talk.